Hi, my name is Sarah Nance, and this is my Tort Liability Module 12 for EDL 850. So let's start with some definitions. A tort is a civil wrong, basically. So a remedy may be obtained usually in the form of damages or monetary compensation. Tort law concerns civil wrongs and addresses the duty, breach, and injury sustained to an individual as a result of another's conduct or misconduct, and that was provided in one of the resources for this module. There's two kinds of torts. Intentional torts are less common but still exist. It's when an individual intends to harm another for assault, battery, false imprisonment, or defamation. Negligence torts are where teachers fail to exercise good judgment, which leads to injury or harm of students. So in a negligent tort case, you have to determine one of four things: that a standard of care has been breached, that there's been a breach of duty of some kind, there's causation or approximate cause, and then of course injury. Guidelines for educators is basically that they should use good judgment, to not make up rules, to document incidents when they happen, perform their duties as contractually obligated, and to keep information secure. So of my 5 cases, the first one is Frame versus Como. In Frame versus Como, a student named Casey Frame was forcefully removed from the class, or tried to be forcefully removed, by a substitute teacher named Barry Como. He was asked to leave twice for being disruptive during a spelling test. Como approached the desk. Frame rose slowly in a threatening manner, which caused Como to grab Frame's arm, and then he stumbled, fell, and injured himself. So Como was sued for assault and battery, so an intentional tort, but the court ruled that Como's actions were justified because as far as corporal punishment goes, that he acted in a manner that was pursuant with that, because the student was making a threatening move. So for an evaluation of this case, in my school, the sub probably would have been asked not to return. Now this, in my school, happens for way less serious infractions. They just kind of go through subs all the time, so I guarantee you that sub would not be back. If it were a teacher, that teacher would be placed on administrative leave. I think probably a letter to parents in the classroom at the time of the incident would be sent. And our school, being that it's so big, is really susceptible to media attention. So I'm sure there would be media attention. There would be for all these cases in which students are suing the school district for torts. So proactively, I think there could be a code of conduct in relation to district policies for subs. I'm not sure that one really exists, but there should be. Classroom management training for subs. Some subs are former teachers, but a lot of them have been out of the classroom for a long time, so maybe some just initial training at the beginning of the year for subs. I would encourage classroom teachers to provide disciplinary action steps for subs to take for students who are disruptive, so it doesn't escalate to the point in which it did for this case. So for a set of ethics, the benefit of that, parents and community would be assured that students are in equally sound care when a sub is in the classroom or a teacher. I think they should be expected to, or they should expect that kind of care for their students, even when a sub is there. My second case is Flanagan versus Canton. In this case, students were being disruptive during a PE class. They were getting a little bit aggressive. And as a result, despite a lecture from the teacher, students were excused to change clothes for the next class. But one student, Flanagan, he needed a splenectomy after another student pushed him. So the students were excused to change their clothes, but in the locker room is where things escalated. So Canton, the teacher, was sued for negligence since he was not supervising the locker room as contractually obligated to do. He was lecturing another student outside of class. But the court sided with the student, ultimately determining that this teacher should have taken special precautions with the students that day, especially given the nature of that class period, but he didn't, and that's why the aggression happened, and then the student was injured. In this case, get rid of that. In this case, reactively, what would have happened in my school, we have a crisis team that meets when students are going through something serious, like needing surgery at the hand of a class. I guarantee you the crisis team would be meeting with how to best deal with this. I think there would be a lot of support of the teacher, given the nature of the class and trying to do what's best for all students. He stayed after class to lecture a student. I think this teacher was probably acting in best interest, for the students in general by lecturing the one student, but it caused this other thing to happen. So there would definitely be support of the teacher, but there's a concern about the classroom management being obvious. So it probably needs some revised discipline policies about how to de-escalate students when they rise to kind of a fever pitch in which this is the result of their actions. Proactively, I think to readdress district policies about monitoring students in locker rooms would be good for all teachers who have that responsibility, coaches included. I think the class, I believe there were a class full of boys, so maybe more balance in the classes with girls or boys, or smaller class sizes. Teacher aides or student teachers or other teachers who can help, especially at the end of classes, to kind of be floating through the locker room. I know at my school, all the teachers who have PE classes, they're all kind of supervising the locker room at the same time. So there's more than one teacher responsible for that. So we could put that into place. For professional ethics, teachers have the responsibility and duty to ensure the safety for all parts, for the students in all parts of the school, including the locker rooms, fields, and gymnasiums. My third case is Brahatchik, I think. Brahatchik. I think I said that earlier. I said it earlier a lot more fluidly, versus the Millard School District. In this case, the mother of David Brahatchik sued the school district for being negligent after her son was killed in a PE class. And this one is particularly troubling. So the student, it wasn't on a backswing, it was on the front swing. A student killed David, and it's horrific. He died 2 days later in the hospital from his injuries. So during that day, golf instruction was inside due to weather. Teachers were not watching the student. His name was Mark. He was giving instructions to David before swinging and accidentally hitting David in the head. David had been absent the class period before, so the other student, Mark, was giving him lessons, and obviously the teachers weren't aware of what was going on, and it led to David's demise. So the court did rule in favor of the Brahatchik family, noting that the lack of supervision for this incident was the proximate cause of death for David Brahatchik. This one's huge because a student actually died on school premises. Of course, the school should be or could be liable when this kind of thing happens. So again, supportive teachers, I think people would like to believe that teachers act in the best interest of all students. But this was an unfortunate occurrence in the classroom. Again, I think media would be all over this. I think there would be an appeal to court regarding foreseeable injury. Could the teachers foresee that this was going to happen, and did that result in negligence because of it? I'm not sure this was a foreseeable injury, although the court did rule in favor of the family. I think we would have to look at absence policies regarding instruction if a student is absent. We can't leave it up to other students to talk about safety with golf clubs. We really need to pull those kids aside and give them a separate instruction. I believe when I looked at this case, there were 58 students in the class, majority being boys. And, there were 2 teachers, but there was only one real teacher, and then there was another student teacher who were in charge of 58 kids. And I think probably legally that falls within the standards, but it wasn't good enough, and it resulted in death for a student. So that's obviously an issue. I think smaller class sizes would have to be considered, or more qualified teachers, 2 qualified teachers. So proactively, maybe no golf instruction taught inside. It's a pretty aggressive sport to move into close quarters, balls flying, clubs swinging. Smaller class sizes, I think this is a giant class for PE, even, at every level, high school, middle, and elementary. Classes over 30 for any teacher is just going to be kind of a management crisis at some level, at some point in the year. And if students miss the first day of instruction of a new sport, they obviously need to be placed on a separate group and taught the initial instructions for safety. This requires 2 teachers because one has to go watch the other part of the class and the other has to be responsible for teaching safety measures for the students who are absent on previous classes. So again, 2 teachers. The set of ethics, students should expect proper training despite their absences. We can't control that. Teachers have a duty to keep the learning environment safe at all times. That goes for pretty much all these. My 4th case is Johnson Johnson versus Millard School District. Lynn Johnson, on behalf of her son Robbie, sued the school district for negligence of care when her son was injured during a game of London Bridge. The teacher had taught the students how to play London Bridge, and Robbie was number 3 in the mix of the little group, and he got roughed around too much, caused him to fall, stumble, hit his head on a bookcase, which caused permanent disfiguration, they claimed. He claimed that he tried to ask the teacher for help or ask the students to stop, but no one heard him, no one listened to him, and that was the result of the game. So the school district was found liable, and the family was awarded monetary damages of over $20,000 because they were able to prove that the teacher had acted she had breached her duty, which was to provide reasonable supervision, reasonable care for the class. So upon evaluation of this one, again, administrative leave, I think that's pretty standard. I don't know if London Bridge has a lot of educational value, so we might have to review that. I think, again, we would support the teacher for the lessons and activities she's choosing to use in her classroom. However, I would imagine a staff meeting or some professional development about sound classroom procedures and activities to keep students safe and learning would have to be readdressed. Proactively, we would need to remind our teachers that students at tender ages need constant supervision when there's a potential for roughhousing or injury in the classroom. Again, professional development about that. I think communication with parents, even waivers or permission slips for potentially harmful activities could be given out so that we kind of cover ourselves if this is going to be part of our curriculum. A set of ethics would suggest that teachers, again, ensure that a safe learning environment exists for all students at all times. Classrooms, of course, paramount in that. Teachers should be in contact with parents to educate them on the kinds of activities that students will engage in and field questions or concerns ahead of time so that parents know what's coming for a given day and maybe can talk to their students too about proper ways to handle themselves in a classroom. But parents should feel safe that their child is safe at school, free of negligence. Finally, my fifth case is the Hoyam versus Manhattan City Beach School District. This one was popping up on a lot of my searches. There's a student in summer school named Michael Hoyam who left the school premises early. He was truant. He then was struck by a motorcycle at an intersection and seriously injured. When he was taken to the hospital, his mother suffered emotional damages by seeing him in that state. And they sued the school district for negligence since it did not exercise reasonable care of duty, and they basically allowed him to leave the premises, which then resulted in his injuries. The court ruled initially in favor of the school district, as Michael had been truant, and once he left the premises, the school was no longer in charge of him. However, upon appeal, the family won, since it's within reason to expect students to be in the care of the school from bell to bell. Because he had left early, that was negligence, and then that resulted in his injuries. They also talked about how it's reasonable to expect students to want to ditch because it's summer school, and that this reasonable care of supervision was not exercised when it should have probably been heightened during the summer, which again resulted in his injuries. So finally, the evaluation of this case. In my school, I think a letter to parents about what we expect students to do while they're in our classrooms for summer school would be absolutely sent out. There would be probably an observation of that teacher. I don't think in summer school teachers are evaluated or observed at all. I know I've taught summer school and there's no accountability. I'm guessing for that teacher they would have to be kind of monitored about some of the activities that are allowing students to feel free to leave or kind of sneak out. That would definitely probably come down. I would say there would be some guidance on lesson planning and activities that are appropriate for summer school to ensure that students remain in their seats. Proactively, I would say better security in summer school, trying to prevent students from leaving the classes. Probably harsh punishments for ditching class or some incentives on the other side, like incentivizing the students to stay in class, but also harsh punishment if they leave, such as not passing the course, even if you sneak out a minute or two early because of the legal liability that teachers and school districts face because of it. I think proactively we could remind summer school teachers that though it's summer, there is still a cost if students leave early, or we are really tightly enforcing some disciplinary actions and rules that exist for those students too. Professionally, summer school or not, parents should trust that their students will be supervised from portal to portal when left in the care of the school. Summer school is an extension of the school year, and activities and lessons should be equally rigorous, even for credit recovery. I think that would ensure that ethically we're doing all we can to help students the best to our ability. So these are some of the cases that I found. There's obviously many more, unfortunately, but these are some ones that stuck out to me for a variety of reasons. So thanks for watching, and I really enjoyed this one.